All right, it looks to me like we've got very good turnout this morning. Lots of folks on. I think we should probably go ahead and get started. Well, good morning, everybody. Welcome to the third day of Bracewell's Spring 2021 Environmental Law Seminar. This morning's presentation is going to be a panel on trends in environmental criminal enforcement, discussing how to approach prosecutors, what rises to the level of criminal intent, best practices for in-house counsel when confronted with possible criminal activity or investigations. I'm Tim Wilkins from the Environmental Group here at Bracewell. We are joined this morning by Kevin Collins, longtime partner in our Environmental Strategies and Government Enforcement and Investigations Group. He's a former assistant U.S. attorney, resident here in Texas. He's got tremendous experience not only with criminal matters, but with incident response issues, which, as I think everyone on this call will know, incidents are a driver of criminal enforcement activity these days. I'm also very, very proud to introduce our newest partner, Seth DuCharme, who recently joined our Government Enforcement Investigations Group in New York. Seth previously served as the Principal Associate Deputy Attorney General of the United States. That's the highest ranking career official at the Department of Justice, and most recently is the Acting U.S. Attorney for the Eastern District of New York. So without further ado, welcome, Sean, Kevin, good to see you. Let's go ahead and get started. Seth, you recently joined us from a career inside government, both at the U.S. Attorney's Office and at Maine Justice. Our audience today is made up of sophisticated environmental professionals and attorneys from all around corporate America. What's important for this audience to know when it comes to possible criminal enforcement?
Yeah, thanks, Tim, and it's really great to be here with you and Kevin this morning and to join this group. I have, just as of last month, I was still in the government, serving as the acting U.S. attorney, and before that in the DAG's office. And so a lot of the matters I touched towards the end of my career in government were essentially matters where an investigation had played out for a while, and then there was some type of appeal, frankly, or request from a corporation or individual that rose to the level of those senior offices. And one thing I can say at the outset is, the United States government is dangerous. And I don't say that in a critical way. It's supposed to be dangerous in the enforcement space. That's what deters bad actors, provides, general and specific deterrence, and levels the playing field for good, honest corporate citizens. But, we need to remember at the outset that the government is investigating because they don't really know exactly what happened. And if you have the sense, well, I didn't do anything wrong, so I'm not going to get in trouble and there won't be any consequences for me, that's ultimately true. But at the outset, even the existence of an investigation can have consequences for corporations and individuals. It can create internal stress. It can spook counterparties. And so right from the outset, if an incident happens and you were to stand in the shoes of the government, imagine that the government's suspicious, you really need to establish a clear and consistent communication with whoever is knocking on your door, or even consider being, proactive in engaging the government. That steady messaging, that cooperative, but thoughtful approach, and understanding that there may be a number of different investigative agencies involved, and that can be confusing for corporations and individuals. The first knock on the door might be the agent, and then a call from a local U.S. attorney's office, and then the understanding that Maine Justice is involved. And so it can be a little confusing at the outset for subjects or witnesses, or worst case scenario, targets in an investigation, to really know who they should be talking to, and when. And that's why the messaging needs to be so consistent and steady right from the outset.
Yeah, Tim, I'd like to add, I agree with Seth, and I'd like to just add that, I think anytime you have a shocking situation such as a criminal investigation, or at least word that there are investigative agents poking around your business, your operations, I think you really need to meet internally quickly and get alignment, because you're going to have different people with different ideas about how to react to this. You're going to have, maybe people in the operations unit that says that's hogwash. You're going to have people in the senior executive team that are going to want to go one direction. I think, for the lawyers in our audience, it's really your time to step up and sort of assert a little bit of control and say, look, we've got to get our internal stakeholders aligned because we've got to give a unified message to all the different government agencies that Seth was describing, because they're not aligned sometimes. So it's important that, the client is aligned.
Especially for folks like our audience who are not going to be accustomed to being targets of criminal investigations. There's sometimes a tendency when there is that knock at the door. There's an idea that, hey, maybe we should call someone. We know some senior folks at DOJ or at the U.S. Attorney's Office. Let's have the CEO or somebody from the C-suite call those people in senior management and try and take care of this. Is that a good idea?
Not necessarily as tempting as it might be. And look, Kevin's walked folks through this experience, shoulder to shoulder, and I'm sure he's probably had to take some of those requests. Hey, I know somebody at a senior level. Let's make the call. I can tell you from being on the other end of those calls, at different levels, the risk for you if you immediately reach out to, let's say, the Deputy Attorney General's office, who's going to be the ultimate arbiter in most cases. Rarely do these matters reach the Attorney General, but sometimes the Deputy Attorney General will get involved and has a large staff. If you reach out immediately at that level, particularly if you're reaching out to complain about something, what's going to happen on the other side is there's going to be an information call, because rarely do the senior leadership offices focus on a micro level on what's happening in the field unless it gets elevated. So the problem for you is if you call senior officials, in any of the leadership offices of any of the executive agencies, and you complain, they're gonna ask their chain what's happening, and the reporters of that information are probably going to be the people that you're complaining about, right? And they're going to inform those senior officials. So I can't say, it's never a good idea if it's done in sort of a nuanced and a thoughtful way. In other words, if you're projecting or if you're communicating, the spirit of cooperation, good news is always welcome. And you might be preparing the environment in a positive way for an ultimate, dispute that reaches that level. So for example, if Kevin has a friend at a high level or somebody in the company does, and they informally say, hey, I'm sure you're tracking, but we got a subpoena, or I'm sure you're aware, but we've got to reach out by some investigative agency. And of course, we're doing everything we can to be helpful. That can be good, because at whatever level, and frankly, I think that's what you should be communicating at every level, that spirit of cooperation. Doesn't necessarily mean, you're taking all the files out of your drawer and handing them to the first agent who knocks on the door, but communicating that spirit of cooperation at every level will serve you well, whereas immediately calling the highest level person to complain about the line people and the investigators in the field, probably not the best strategy.
Yeah, and Tim, I wanted to add to that you got to be strategic when you start to reach out to other folks in the government, whether you're going above their head like Seth was describing, or even taking advantage of that natural tension we were talking about between the various modes of government that might be involved in a case. I mean, just recently in the Southern District of Texas, I was embroiled in a long case, had a couple of young, smart, aggressive fraud lawyers. They really had their hands on a huge case of national significance, and they didn't have the experience to know when to give a little bit. And, we were trying to resolve the case for an executive, and eventually I just sort of did go around them, but I did it at the right time, and I did it with the local U.S. Attorney's Office. Instead of going above them, I sort of went sideways and got, a more seasoned AUSA and his boss to say, look, guys, let's go to the woodshed. This isn't the one, this isn't the hill worth dying for. So, you just have to be strategic. You don't want to use that asset that you have too early, particularly when you're going above their head. You go off to some congressman or some senior ranking member, they don't know anything yet, and they're not ready to go out on a limb for you quite yet. So you just want to be careful.
Yeah. Seth, on that issue, mentioning the U.S. Attorney's Office versus Maine Justice, tell us a little bit about the tensions that can happen in that setting.
Sure. And look, I've seen it on both sides, having gone, from the U.S. Attorney's Office down to D.C. for a while and then back. I've really been sort of, sympathetic to all sides. I think what can create the tension and potentially the challenge, um, for the subjects or the witnesses or the targets of these investigations is who's controlling the tempo, essentially, of the investigation, and who's sort of pushing to get to the front of the pack to be the face of that investigation at any particular time. And like Kevin was saying, it's not, I wish I could say it's as simple as, the U.S. Attorney's Office goes fast and Maine Justice goes slow, or vice versa. Sometimes it's really personality driven, which won't be a shock, I'm sure, to our listeners. But you have forward leaning people in a number of components in the U.S. government. The U.S. Attorney's offices tend to be, geographically closer to the incident. And so it may be sort of present for them, staring them in the face. They may know some of the parties or the lawyers as repeat players. And so I think there's been a tendency at times for the U.S. Attorney's offices to be the first face or the faster moving face, but not necessarily. Kevin points out an example where it was, I think, some other folks, or I was aware of, I think, of examples where it might be somebody in the fraud section who's leaning forward, and it might be, somebody in the U.S. Attorney's office who maybe sort of gently pulls the reins or has the voice of wisdom or can do a little course correction. But that's what's built into the bureaucracy of the Justice Department and some of the other executive agencies. There's always going to be a relationship, between the field and headquarters to one degree or another. And then there are going to be components within headquarters, whether it's the Justice Department or the investigative agency, that have this type of investigation as their specialty, and that's what they're tasked to do. And that's what they're incentivized to show progress in. And so I think that's where you have to be just cognizant about who you're talking to and when, and ideally the tempo of the investigation and your involvement in it could be synchronized. But don't be shocked if there's not perfect synchronicity out of the gate. And I would say just, try to always be the most reasonable person in the room whenever you're talking to any of those components. And hopefully, the tempo can be adjusted to a point where your ability to get ahead of the investigation a little bit so you can figure out what's going on in the corporation becomes a viable strategy.
Yeah, Tim, I would add to that sort of areas of specialized investigative practice areas of the prosecutors and certainly of the agents that, I think particularly with Maine Justice and with changes in administration, there's a lot of policy goals, I think, behind Maine Justice, and that can sort of, focus the effort. One of the big differences between federal criminal investigations and state criminal investigations is oftentimes federal investigations, particularly in this space, in environmental health and safety, can be proactive, and whereas in states it's often reactive. But it's those policy goals, I think, that make a difference too.
Fun, Kevin. That's a great segue to my next question. Let's start with Seth on this one. But what's your view or your expectation regarding the criminal enforcement goals for the Justice Department in this new administration?
Yeah, so some of what it comes down to is not necessarily, a material change in the work that's getting done, but a way that work is being highlighted and messaged, and the way it's communicated from the department definitely has a material impact, on the landscape, because it creates expectations. And what I mean by that, Tim, is, it's while there's an expectation that the Biden administration is going to emphasize compliance work, cases related to climate change, environmental crime, civil rights, things they've talked about. That work was going on previously. I mean, we could point to a number of cases that were that existed in the last administration, but maybe didn't get the same level of attention or focus. And so if you look, for example, at recent DOJ press releases, I think Kevin was prescient about this when we were preparing for the panel, but the department has started to highlight For example, an FCPA case with some historical conduct, they issued a press release, and some healthcare fraud and COVID fraud cases. So I think what people are expecting is the department to be more energized in this area, and I think they will be. It's not to say they weren't before. When the fraud section was there before, when we'll be there again, regardless of administration change, and some cases tend to have life cycles that don't naturally sync up with administration changes. But it's where is the energy going? At what level in the department are the officials speaking publicly? And that does change the environment and incentivizes investigators. It incentivizes agencies, to move more people to look at the problem, and it ups scrutiny. It increases scrutiny on corporations and individuals.
Yeah, I agree with Seth, and I think in particular for this audience this morning, and Seth talked about how sometimes the investigative life cycle doesn't really sync up with the different administrations. I think if we go back to the Obama administration, there was really a focus on worker endangerment, moving OSH Act-led cases out of the Department of Labor and putting them into the Department of Justice's Environmental Natural Resources Division. And memoranda were put out, and it was a real big initiative. And then I think in the Trump administration, that sort of ground to a halt, really, unless it was a particularly egregious example. We just didn't see a lot of investigative activity around that. I think that's coming back. I think going forward, when there's workers in danger, the sort of labor alignment, that the Democratic Party believes is, still part of their core, is going to drive a little bit of that. And so I think we'll see that. Like Seth mentioned, we were chatting even this morning that COVID-19 fraud obviously is going to be a big thing. And then I think, Tim, something that you know a lot about in the broader practice group, just environmental justice. I think when there's an environmental justice angle to a criminal investigation, you're going to see that.
No, that's exactly right. I mean, the Starfield memo out of OECA at EPA mentions specifically targeting criminal enforcement activity to EJ communities. In fact, we have a whole panel on environmental justice coming up right after this session, and I hope everybody will jump over to that link when we wrap up here. Kevin, how has environmental justice as an issue come up in some of the EHS incident driven cases that you've been involved with?
Well, it's definitely a selection factor. I think one thing that, if you haven't been inside of government, you can be sort of amazed by sometimes how mathematical it can be with some of these investigative agencies trying to work through what it is they're going to target and what they're not going to target. And, certainly when there's fatalities, when there's substantial property damage, when there's significant injury, those are always things that get the government's attention. When you shut down critical infrastructure, you're going to get the government's attention. But increasingly, I think the thumb's on the scale when you have a potential crime or potential incident in a depressed socioeconomic area. That's going to get the government's attention. And, I just went back in preparation for this, frankly, and looked at some of the comments that various people have made around this issue. President Biden talks about, the ripples of trauma that flow through these communities. Merrick Garland specifically appeared as a guest speaker in an otherwise pretty low-level presentation and surprised everybody, and talked about how communities of color and low-income communities bear the brunt of environmental crime and face barriers in accessing justice that they deserve, particularly in the fence line communities, which should, be a phrase that resonates with our audience this morning. Concerns about workers not having the appropriate personal protective equipment. There's a huge investigation right now at a lead battery recycling facility out in Tampa Bay, Florida, and it's because it's in one of these communities of color, and it's the subject of a pretty good expose from Frontline and the local paper. Michael Regan has a background in social justice and has stated that it's going to be an integral part of all EPA policy, including criminal enforcement. And finally, there's the Environmental Crimes Victims Assistance Team, right, which really can drive investigations. And they have an initiative to ensure that all these people in these communities and these workers are kept up to date on the progress of the investigation, particularly when it goes overt. So as a practical matter, if you have an incident, if you have an allegation or a whistleblower, and you're in an area that's going to impact a historically underrepresented community or low economic area, you're going to probably get more attention.
Yeah, and I can just add to that a little bit, Tim, if I can. People need to realize it takes very little, frankly, for the government to open an investigation. And the existence of an investigation can create stress in a corporation that's not prepared for it. And like I said, spook potential counterparties. So, there's obviously some comfort from knowing that you're not doing anything wrong and that you ultimately are following, the law and are not facing real criminal exposure. But just that the existence of an investigation can be potentially prejudicial to a corporation. And corporations have the ability at the outset, if they handle it deftly, to mitigate whatever prejudice they might suffer, and even ideally to turn it into a positive, to align themselves with the white hats early on, essentially to mirror the same concerns that the government's responding to. In other words, we care deeply about, corporate culture, being a responsible corporate citizen. But I have to just caution folks, that doesn't mean you won't get a knock on the door. Quite the opposite. I take Kevin's point and strongly agree with it. In the current environment, there's going to be a lot of inquiry and investigation just to satisfy some very vocal critics right now that things either are okay or not okay. And that's going to place some demands on companies.
For sure. Seth, Kevin mentioned incidents. You've been in the government for some very significant incidents involving both environmental impacts, potential terrorism issues. What can you share about what the government expects when it shows up in the wake of one of these incidents?
Sure, and this is where I think there will be alignment, certainly alignment in principle with the companies and the government, but the way it plays out is not always seamless. I mean, the first priority is going to be safety, right? So whatever the incident is, and I think we can all agree, you need to sometimes literally stop the bleeding, contain the problem. If there's a fire, it needs to be put out. If there's injured people, they need to be cared for. If there are sections of a geographic area that are endangered, they need to be cordoned off. So public safety is always going to be the priority. Where that may come into tension is if it's an incident that's specific to your industry, and I'm just speaking anecdotally here from a press report. I read recently, and I don't have any inside knowledge, but I read recently, that an electric car caught fire, and the firemen couldn't figure out how to put out the fire, and they had to call the company to understand the chemistry behind how that vehicle worked. And so sometimes there's going to need to be really seamless communication on the front end between the corporation and the government, just to contain and mitigate what the potential harm is, whether that's a data breach or whether it's a fireball. That's going to be the important conversation. Now, what happens after that then gets into a grayer area, because as soon as the public safety concerns are satisfied, then the evidence preservation and investigative step process is going to play out almost immediately. And the players aren't always completely synced up as when, we shift from the public safety emergency to, okay, now let's preserve the crime scene and start talking to everyone and figure out what happened. In other words, was this an accident, a terrorist incident, state-sponsored attack, freak, act of nature? What was this? And in that area where you transition from, contain the emergency to preserve for investigation and start cooperating, that's where things can sometimes get a little shaky.
Yeah, and actually they do get shaky because, Seth's absolutely right. When you've got an incident and you've got some ongoing safety concern, it's really the incident commander that trumps everybody. And whether, if it's a big enough incident, that's going to be a government-based incident commander. If it's a little smaller, it may be a company-led incident commander. It may be a unified command under the incident command system, the ICS system. But Seth's absolutely right. There will be a moment where things are sort of under control, and all those investigative agencies, particularly the criminal ones, want first dibs. They want first, strike at that thing, and they want to set up an evidence preservation zone. They want to go into the debris field. They want to try to figure out what caused this thing, and they think they get it first. And I've seen this problem. I've seen sheriffs, in the immediate wake of an incident, sort of redirect personnel and send them the wrong direction because they don't appreciate wind direction. They don't appreciate what direction the bad stuff may be going. Certainly when the investigators show up, they have no idea what all these companies' processes are. They really don't. It's a flux capacitor that makes a widget. So I think getting people sort of aligned is really important, and help them understand what it is that they're facing. But I've got a couple of questions for Seth. Tim, I don't mean to step on your toes, but I'm excited because Seth's joined us. And he's got the most recent inside baseball playing card, so I want to ask him some questions. But so I want to change the facts up, because I think as you and I answered Tim's question, we were thinking about obvious external triggering event like an incident, but I want to bring it back to sort of criminality. What happens when the company discovers what the company believes, or what someone in the company believes could be a criminal event? How quickly, if at all, should the company disclose that information to the government? Everybody's leaning in, right? This is the $1 million question. So what do you think?
Right, and I'm going to try to give you what might be more satisfying than just a typical "it depends" lawyer answer on this one, with some real examples. Because you're right, Kevin. That is sometimes the $1 billion question for where your company ultimately ends up. And I think at the outset, look, the leadership in the company has a fiduciary duty to know what's going on in the company, and is going to want to know what's going on. And inside and outside counsel can't even begin to assess exposure until there's some command of the facts. So I think, the critical part of your question is the could be, right? Could be criminal activity happening in the company. I think, and there may be some tough calls to make here, but if it ultimately turns out that there is criminal activity in the company, the sooner the company brings that fact to the attention of law enforcement, the better off the company will be if there is corporate exposure under respondeat superior, or worst case scenario, some senior officials may be mixed up in the conduct. To protect itself, the company wants to emerge very quickly as the white hat, wants to be the reporter of crime, not the committer of crime, and wants to be able to isolate the bad apples in the barrel from the overall culture and structure and leadership of the company. So if you determine early on that that's where this is headed, yes, we've identified criminal activity in our company. Good citizens report crime, and good corporations with the benefit of counsel can do it in a way that ultimately benefits the company by essentially saying, it was us and law enforcement working together, to identify these few bad apples and carve them out. And that's not us. This is not representative of us. The tricky part is when the facts are ambiguous, or when the government is aware of partial information, and the company's playing catch up a little bit. So, I can give you a couple of examples, I guess, on extreme ends. One, if there's a public event of the type we were talking about, an incident with a fireball, and there's even an indicia of responsibility from within the company, I think the company has to proactively move very quickly to get a handle on the facts, to proactively engage with law enforcement, because you just know they're coming. So it might as well be, what I used to say is the companies in that posture, look, it's either you call us or we call you, but there's going to be a conversation, right? And so if you can reach out in the first instance and start to proffer, sometimes caveated, but proffer some representation of the facts known to you at the outset, you can get off on a very good foot, because ultimately you'll be able to argue either internally to the government or externally to others. We deserve full cooperation credit. From the moment we learned of these facts, we were synced up with law enforcement, working collaboratively, to identify, isolate, mitigate, contain ultimately punish and deter this type of activity that we identified. It's the ambiguous ones, which are the harder ones, where you learn of possibly something wrong in your company either through a press report or through an initial engagement, a knock on the door from an investigator, and you don't have a full command of the facts, but let's say you see some indicia of maybe a problem. And I'll just give an example from an old case I worked on. An internal email where one employee, says to another, "Hey, did you hear about what happened?" Referring to something in the company. And the response was, "Shut up and delete this email," with an exclamation point. That doesn't look great. But it's not necessarily ultimately conclusive of a criminal mind within an employee. So I think the balance is leadership in the company has to quickly get a firm enough understanding of the facts and a reliability assessment of their understanding of the facts. And if the scale has tipped towards, yeah, we really think a crime has been committed and some of our people may have been complicit, then I think you have to contain and compartmentalize that, and you've got to go proactive. And the more likely it is to be public, or the high profile it is, the faster you can expect the tempo to be in the investigative agency. I mean, you could, if it's hit the press, you can expect your phone to ring. So unfortunately, sometimes you have to move fast, but if you move based on unreliable information or an incorrect inference, then you can draw negative attention to yourself and prejudice yourself in ways that could be avoided if you maybe just took a little bit longer to get a handle on the facts. So that may not be a completely satisfying answer, but that's how I've seen it play out.
No, that's good. And Tim, in our environmental and health and safety space, what are some tools from your perspective if it truly is self-discovery, not an external trigger, but Tim, from your perspective, what are some thoughts there?
Well, in the environmental arena, we who are more subject matter experts, not defense lawyers necessarily. I mean, I think there is a real opportunity to add to the environmental regulatory and statutory understandings and to communicate maybe with the agencies, not the DOJ necessarily, but with the EPAs and the EPA CIDs, right? I think we have an angle for communication there that can really be additive. But there's also sort of this whole preventive side of the world. You can't have criminal violations if you don't have violations. And so robust compliance programs are really a huge part of what you need to do. Self-auditing, maybe I'm a hammer and all I see is nails, but audits is something that I have found so valuable as a way of getting ahead of these types of issues and self-discovering problems that are there using the audit disclosure tools that are available under EPA's audit policy, under the Texas Environmental Health and Safety Audit Privilege Act. So many states have policies or statutes that you can take advantage of in that space, and more states coming online. Oklahoma adopted an audit statute recently that mirrors the Texas statute, really positive development there. But with auditing, you can stay ahead of the agencies. You can provide that robust compliance assurance, especially as we emerge from the pandemic, where there may not have been, eyes on the problems or the potential problems the whole time. It's a really important opportunity, I think, now to get ahead of those issues by doing that kind of self-auditing and so forth.
Well, Tim, I don't mean to co-op, but I did have two questions, so I want to get back to Seth. But before I do, you've given me the quote of the year because I think we should make a T-shirt. You can't have criminal violations if you don't have violations. Those are magical words to live by, honestly. So Seth, you mentioned proffering, and for our audience who hopefully has never had to do this, a proffer is where you sort of set up a formal conversation with the government under some protection to sort of outline some facts. But it's a nice segue to my other question, which is, what was your reaction as a senior ranking government person in the Justice Department and the U.S. Attorney's Office, for that matter, when a company says, "Well, okay, Mr. DuCharme, we got this. We want to do an internal investigation," because I think that's another question where people, they don't know what your reaction is. So maybe you'll share it with us.
Yeah, and I will make that specific to a case, of course, with a little anonymization, because that was an investigation where ultimately there were no charges brought, and sometimes that's the right outcome, right? I mean, often that's the right outcome. So managing the momentum of an investigation is important. But in the case I'm thinking of, Kevin, I was supervising an investigation at the U.S. attorney level, and we had some indication of some potential criminal violations within a company that did international business. And two very able former prosecutor lawyers came in to talk to us early on, and one thing I thought they did that was highly effective was they conveyed, to us as the government, that they were as or more concerned with the possibility of a violation, than we were. So they said, we're alarmed, to hear that you're looking at our company. We take this very seriously. We want to get to the bottom of this. We obviously, want to work with you in a complementary way. This is, unacceptable to us if this is happening. So notably, what they didn't say is, oh, this is ridiculous. You're barking up the wrong tree. Move on. I can't believe I'm being bothered. They really projected that they were even more concerned, perhaps, than we were. And the question that they posed, which I think is the one that you're getting at, is they said, look, we want to know what's going on in our company. We have fiduciary responsibilities with our leadership. We have resources, but, we don't want to interfere with your investigation in a way that's not helpful. So would you like us to quickly do an overt, get to the bottom of this internal investigation? Or are you telling us, that you want us to stand down? Or, are there certain things that would be helpful for us to be focused on right now, but other people, for example, you would want us to avoid because it might interfere? And it was a really interesting question, because in order to answer that question fully from the government's point of view, we had to give some visibility into what our investigation was, which we typically, don't like to do. And there was a balancing there, because if you have confidence in the company at the outset, and this was a company, great outside counsel, some confidence in at least certain aspects of the company, it can depressurize the situation a little bit, and the government may say to the company, yes, it would be very helpful if you started, for example, gathering responsive documents, identifying potential witnesses. But in that case, we said, please don't, go too overt at this point, because we're right at the inception. And they were, happy to work with us on that, and therefore could never have been accused later of either being obstructionist, by running around telling everybody, the government is coming, in kind of a reckless way and making it more difficult for us to approach certain witnesses. They couldn't be accused of that. And they couldn't be accused of underreacting either, because they essentially said, we're committed to get to the bottom of this. We want to work in a complementary way. We know our business from the inside out, and, we want to get going. And that put them in a great spot. Ultimately, no charges were filed. I don't even think it ever became public, to my knowledge. And their outside counsel really helped them navigate through. It's going to depend a little bit on, what the government knows and how much it already has and how much faith it has in the company or outside counsel. But that conversation can be very, very productive if handled, in an earnest, honest, and kind of a nuanced way at the outset.
So we are down to 3 minutes, so we don't step on the environmental justice panel that follows. And so I want to ask Kevin the sort of 1 minute question. Are there any big environmental crimes developments in terms of how the government's approaching these issues today?
Yeah, I think so. The number of agents is up. It's not to its peak. 10, 15 years ago, we had over 200 EPA Criminal Investigative Division agents. We're probably down to 160, 165. I think they're really looking for financial motivation. If they can find financial motivation behind an environmental crime, they're going to pursue it. We talked before about the interplay between worker safety. I think that's another big angle. And then, one thing about our environmental space is the Clean Water Act is just a negligence standard, a simple negligence standard for some criminal violations. And then this audience has heard me say this before, but I'm going to get on my soapbox and say it again. Prosecutors are generally not that excited about complex environmental crimes that involve complex regulations. But if you put a little lying, cheating, and stealing in front of them, they're going to go after that because they know how to try that case. And so when you've got a combination, like Seth was saying, of obstruction or, doing something with documents or, doing something that's easier to comprehend than, how you put together your safety program, I think you're going to get the government's attention.
That is great. We have one audience question, which I'd like to tender to both of you. Again, let's try and keep it to 1 minute here. Could you speak to when and how to lawyer up an individual employee that might be subject to criminal charges within the context of an employee of a company?
Sure. For me, I think, if your employees have a natural alignment with the company, that's no problem. It's when their interests start to diverge that you start to have problems. But, I think if your D&O, your directors and officers insurance allows you to do that, I would definitely get them lawyers and let your outside counsel pick people that they trust. If you find yourself reviewing a 25-page joint defense agreement, that's not the right lawyer.
Got it. We are down to the last minute or so here. Seth, I want to give you the final word. How do you best approach the government? What are the core principles here, given your very recent experience as the government?
Yeah, I would say find alignment early on, and you will be able to find alignment there. An indictment of your company is not in your interest. So find alignment early on. Always express the spirit of cooperation while you're gathering facts. And look, build empathy and understanding. These investigators or prosecutors may or may not be subject matter experts in your industry. Probably not. So the more you can educate them and help them understand what the world looks like, from your side of the table, the better able you're going to be to reach some favorable resolution. So don't take for granted that they've walked in your shoes. They probably haven't, but they should listen to you if you can communicate effectively.
Well, Seth, thank you. That's excellent. Kevin, is always brilliant. Seth, it's so great to have you on board here at the firm. I hope everybody will join us on the environmental justice panel that's coming up next. Look forward to seeing everybody there.
Thanks, Tim. Thanks, Kevin.
Thanks, everybody.
Thanks, y'all.